Okay. Heard the counsel for the petitioner, heard the counsel for the CBI. The prayer for bail of the petitioner was earlier rejected. Full stop. On the last occasion when the prayer for bail of the petitioner was rejected on, what is the order?
Annex 8/2 at 106, 106.
On 9/2/2021, a liberty was given to the petitioner to renew his prayer for bail after framing of charge. Next para. The senior counsel for the petitioner submits that the now charge has already been framed and all the other accused persons have been granted is on bail. He submits that the petitioner is a police official who has been made an accused along with others. Pursuant to along with others. First up, he submits that pursuant to the order passed by this court in BA number
11753.
BA number 8308 of 2017. The investigation was handed over to the Central Bureau of Investigation. He also submits that the aforesaid order of this honorable court was affirmed by the Honorable Supreme Court of India. He submits that after investigation, charge sheet has already been submitted in this case. And there are 120
witnesses.
120 charge sheet witness. So he submits that the petitioner is in custody since 26/6/2017.
Yes,
and it will take considerable period to examine this 120 witnesses. Full stop. Next para. This is a case where the victim was shot dead after he was apprehended by the police officials, including this petitioner. Full stop. Now the next para. इसके बाद लिखिएगा, उसको ऊपर लिखिए. The counsel appearing on behalf of the CBI submits that the investigation has already been completed. Already been completed and admits that there are 120 witnesses who are to be examined in this case. First up, next para. In this, अभी जो लिखा था just वो वाला next para में लिख लीजिए. Considering the next para लिखिए. Considering the fact that the petitioner is in custody from 26/6/2017 and 120 witnesses are yet to be examined in this case, and charge has already been framed, and liberty was granted to the petitioner to renew his prayer after framing of charge, I am inclined to release the petitioner. 20,000 to sureties. One of the bailers should be his close relative. And yes, you have been suspended?
Yes, sir.
20,000 to sure, one of the close relative. The petitioner should cooperate in the trial. Defense ignored.
Serial number 30, BA number 16334 of 21, Ms. Jaswinder Majumdar, Mr. Rohan Majumdar for the petitioner.
No, this is also earlier rejected one, but I could not get the rejection order. It is not on the line, my lord, and it was rejected earlier, my lord, by an order dated 15th of January 2018. BA number 5997. It is a 307, 394, and 27 of the Arms Act. The FIR is against 20 to 25 Bars ke do agyat. Now, he is in custody since 29th of April 2015.
What is the stage?
Out of 9 witnesses, charge was framed on 22nd of July 2016.
Section 302.
Yes, Lordship. In this case, in Lordship, will kindly see impugned order,
Just a
page
minute.
number 39.
Just a minute. Why are you hurrying? Why are you in a
Oh,
hurry?
okay.
This
My lord,
case is under section 302, Mr. Majumdar.
no, no, 307, 394, 34, 27
No,
answer.
no, no, no. Converted under 302. You go through.
Converted, na? Charge frame कितना नहीं हुआ है?
No, no, no. Sorry. Just a minute. Just a minute. Just a minute. This is Govindpur PS case number.
This is Govindpur PS case number. I'll just give you, Lord.
What is the case number?
Yes, minute. इसे नहीं नीचे लिखा रहता है, यहाँ लिखा रहता है, यहाँ लिखा रहता है. मतलब this is registered Parsuddin PS case number 58 of 2014.
This is Parsuddin.
Right.
There are 302 cases pending against you. Tell me what is the status?
Against me, my lord.
Yes.
I'll just inquire about it, my lord. Let it be next week, my lord.
There are 11 criminal cases against you, out
Yes,
of which 3 cases are under section 302 of the Indian Penal Code.
What, my lord? Only my lord, subject to my lord, I'll verify. My lord, here, my lord, he is in custody since 29/4/2015. Almost, my lord, he has served.
Maybe.
Before the trial is concluded, my lord, he will be serving his
No.
sentence.
If you, what happened if there is a conviction in any of the 302 cases?
Yes,
Then
my lord, I'll inquire, my lord. Let it be, my lord, after 2
weeks.
2 weeks.
In the meantime, the defects should be removed.
My lord, one is Okalatnama, my lord, one to be ignored, my lord.
One is already filed.
Okay. Just take it one thing. The defects are ignored.
Yes.
Serial number 31, MN number 9 of 2022, Mr. Rahul Kumar Gupta, Mr. Akshay Verma for the petitioner.
There were 3 defects, Your Lordship. 2 have removed. One was court fee and another was typed copy that I have already filed. The
So all
third
the
defect
defects
is
removed. All the
the
defects
third.
removed.
Yes, there is third defect also.
Yes.
Third defect is I have not filed certified copy of the impugned order. So that I'll be getting on Thursday, next Tuesday. But Your Lordship, apart from this, I have one more difficulty which I must fairly point out to Your Lordship, that the impugned order is only one page which says that the matter is posted on so and so. That I have challenged.
What have you challenged?
Yes, Your Lordship may kindly come to. The suit was filed along with a petition for injunction. The suit was admitted, but the no order was passed on injunction. That I have challenged.
Just a
That Your
minute.
Lordship may kindly come to. At
Just a
annexure
minute.
10.
Where is the impugned order? Let me see this.
Yes, running page 127. This is order passed in injunction petition. It was after the suit was admitted, the only date was fixed, put up on so and so. So, Your Lordship, my only one prayer, I must, I know that whether this appeal would be maintainable or not.
I am dismissing this with cost.
No, I'll satisfy Your Lordship. Therefore, I say.
Satisfied?
Yes.
Give me the impugned order, which is at page.
That Your Lordship may kindly see that when
Show me the
whenever-
impugned order. Impugned order is at page
127.
127 is not also an order. It is just an. It is the report of the CIS.
It was put up on date fixed. That is all.
Yes. So what is wrong in it?
So therefore, I say, Your Lordship, I knew that this problem would arise. Therefore, Your Lordship may kindly note down three judgments I'll be relying upon, because I knew that question of maintainability of injunction, this miscellaneous appeal would also arise in the instant matter. So the order 43 rule 1R says that in an order passed under rule 1, rule 2, rule 4 and so
Order
on,
39.
order 39.
Yes.
An order, it says only an order. Now this
So-
was interpreted by Honorable Supreme Court in the case of that
Yes.
you may kindly take note of.
Yes.
2000 volume 7 SCC page 695.
Yes.
And in that, may I place that?
Yes.
Your Lordship, in that case, facts were a little different, but it was one paragraph was clearly it was said that any order which is passed by in an application under Order 39 Rule 1 and 2, then that would be covered by, and the party who is aggrieved by that order, he would have a right to.
Just tell me this, just show me that this order was passed in your application under Order 39 Rule 1 and 2.
Yes, yes, that is there. Your Lordship may kindly see the top of that case. Case number is miscellaneous civil application number so and so. Nowadays, what has happened? Your Lordship may kindly come 2 pages before that. Annexure 10, page 124.
Yes.
This is the status of the main suit.
Suit is admitted and the suit has been fixed on 3/2/2020.
Yes. And notices were directed to be issued.
And your petition is also fixed on 3/2/2020.
Yes.
This is not at all an order.
Page 126.
I'm dismissing it. Heard the counsel for the.
Your Lordship may kindly see why I said I'm absolutely. I know that this problem would arise. Therefore, I had said.
There is judgment of the Supreme Court deprecating adjournment, filing an appeal against an adjournment.
No, Your Lordship may take 2 cases. Therefore, I said. Now, a party cannot be. What has happened in this matter that a party has been rendered remediless, Your Lordship.
No. What is the remediless? Where is that order?
Now, if there is an urgency and I file a petition for injunction and the court simply adjourns it, then that is the rejection.
When you have filed the petition?
I had filed it, Your Lordship would get that on page 126.
When have you filed the petition?
This I had filed on 2021.
21st of December.
12/1/2022. 12/1/2022.
From where I get it?
Yes. Page 126. Your Lordship may kindly come down. Last case history. Registration number so and so. Subjudge 1. Hearing date is 12/1/2022.
No, that is hearing date. When did you file it? I am asking. When have you filed this? When have you filed this petition?
This is 22/2021. This Your Lordship would get on page 126 at the very top. Miscellaneous civil application, case number so and so, filing date is 2012/2021.
Yes.
And there is one more judgment, Your Lordship, of Bombay High Court.
Yes.
Therefore, those are logical judgment. Your Lordship may kindly see the reasoning. I'm not saying whether I have a prima facie case in this particular matter or not. That would be an entirely different matter. But whenever such kind of order is passed, then what is the remedy for a party who's aggrieved by something?
Which type of order?
Where the court only adjourns it and does not or issues notice. Your Lordship may kindly take note of only 2 judgments I am placing.
Yes.
One was Supreme Court order, which I have just placed, and another is Bombay High Court judgment, which is reported in 2003 SCC online, Bombay, page 89.
Yes, read that.
Yes.
Relevant information.
And in that case, the judgment started with these questions only, which was framed before the court.
Yes.
All these appeals involved common questions of law, namely whether an order passed by trial court to issue notice to the defendants, thereby declining to grant ex parte ad interim injunction, is appellable. Then next question was, if yes, when can an appellate court interfere in the discretion exercised by trial court in refusing to grant ad interim injunction or issuing notice. All these appeals arise out of various orders passed by the trial court declining to grant ex parte ad interim injunction.
No, declining. There is a specific decline.
No, I'll place all those. Your Lordship may only allow me to read further.
Yes.
and or directing issuance of notices to the defendant. The wording of the order is not uniform. However, words used in the various orders are like issue notice to the defendant, notice of motion made returnable on so and so. The second one is important. Notice of motion made returnable on so and so. No case of urgency is made out, no prima facie case. Real substance of all these orders is that the court has declined to grant an
So what
ad
is the-
interim injunction.
Court has declined to grant that no prima facie case and no case is made out to grant. So, but here that has not been held. In fact, there is nothing on record to suggest that your ad interim injunction was refused by.
No. Therefore, I say when the matter is only adjourned and no order is passed, then what would happen?
Yes.
Then, in that situation, the Supreme Court has also said that a party cannot be remedialess.
Yeah, no,
He has a
just
right.
tell me whether, just first come to the basic question. On your application, if a time is granted or a notice is issued that amounts to rejection of your interim application, show me this. Show me from any judgment.
Your Lordship, merely because a date is being fixed and no ad interim injunction is being granted.
So that means it has been rejected.
That is what has been said by Bombay High Court also, and Your Lordship.
No. Bombay High Court, the facts is absolutely different. It was rejected, specifically rejected.
No. First three. Therefore, I said that Your Lordship may kindly take note of issue notice to defendant was first. Second kind of order was notice of motion made returnable on so and so. Nothing was mentioned there.
I differ with the Bombay High Court order. Anything?
So, therefore, a party must have a remedy of moving further.
Remedy of what? What is order? You have a remedy. You could have approached under 227.
No, 227, Your Lordship, because I yesterday I was going through, the Supreme Court has deprecated that practice also, where it says that if there is a remedy, 227 is absolutely not maintained.
What is the remedy? What is the remedy?
Because under 227, what would be my prayer then in 227? I cannot seek quashing of that order. And I cannot.
See, in what circumstances you can file an appeal? Under Order 43 Rule 1R. Tell me.
Therefore, Your Lordship may.
CPC लाइए. Tell me. Let us see. Order 43 Rule 1R.
Yes.
What does it say?
An appeal shall lie from the following orders under the provisions of section 104. And then it says, Your Lordship may, I'll skip all other portions. Rule 1 says,
Come to 104.
Yes. An appeal shall lie from the following orders and save and otherwise expressly provided in the body of this code or by any law for the time being force from no other orders. So and so. All these are there. And therefore, an appeal shall lie from the following orders, and then it says, rule I may kindly be seen, and any order made under the rules from which an appeal is expressly allowed by the rules, so and so. And therefore, order 43 rule 1, that is, if my case is covered under that, then appeal is permissible. So, order 43 rule 1R, Your Lordship may kindly see.
Says an order under rule 1 and rule 2.
Yes.
Of or rule 2A or rule 4 or rule 10 of the order 39.
Yes.
So
it is an order. Therefore, I said,
is this
rule 1R, Your Lordship may kindly see.
Order under rule 1 and 2. Is this an order under rule 1 and 2? Can you say this to be an order under rule 1 and 2?
it would be even an order of adjournment is an order under 1 and 2, because I also pray for a grant of ad interim injunction. That means if I am praying for grant of ad interim injunction and that is not being granted by the court, that is an order. It does not say that any final order of a particular nature.
No.
It says only that an order under order rule 1 and 2. Then your lordship may kindly see that Supreme Court order also.
Yes.
That also your lordship may kindly.
Yeah, read
see.
that.
And Bombay High Court, I
Read
know
the
that
Supreme Court
it
order.
only
Read
has
the,
a persuasive value. I'm aware of that. But your
read the
lordship may
Supreme
kindly
Court
see
order.
the reasoning of that. I'm not saying that it
Read,
has to
read
be.
the Supreme Court order.
Yes. Facts were a bit different, your lordship. I must admit that also in that. But the ratio which has been laid down, that has to be seen.
Yes.
Now, if your lordship would have that judgment,
Yes.
I'm not aware. In para 10 and 11 of that, the Honorable Court quotes section 104 and then order 43 rule 1 and rule 39, order 39 rule 1 and 2. And then it says, para 13, it cannot be contended that the power to pass interim ex parte orders of injunction does not emanate from the said rule. In fact, the said rule is repository of the power to grant orders of temporary injunction with or without notice, interim or temporary, or till further orders or till disposal of the suit. Hence, any order passed, this is the word, any order,
Yes,
any
yes.
order passed in exercise of the aforesaid powers in Rule 1 would be applicable as indicated in
Just
order
stop
43
here.
Rule 1 of the
Just
code.
stop over. In any order passed in exercise of Rule 1 of Order 39.
Yes, yes, yes.
So, do you mean to say that adjournment, the case was, a date was fixed in exercise of the power under Order 1?
Yes, because
Under Rule 1 of Order
the
39.
court below is apparently not granting me an order of interim injunction and it is simply refusing. Therefore,
Just show me,
therefore I said,
just show me any judgment. Just show
I'm
me any
reading
judgment
further
that-
from that
Yes.
same judgment. I'll not say any other judgment.
Yes,
Para 17.
yes.
Yes, para 21, not 17, para 21. It is acknowledged position of law that no party can be forced to suffer for the inaction of the court or its omissions to act according to the procedure established by law. Under the normal circumstances,
to put this, just show me, is there a mandate that whenever an application has to be filed, an order has to be passed on that particular date?
no. But your lordship, if the court simply adjourns it, that means it is refusing my prayer for grant of ad interim injunction.
No.
Therefore, I may be allowed to read further this particular paragraph and then
First
whatever.
bring the order. Well, you are arguing without the order. First bring the order.
Okay.
Because the impugned order is not on record. The counsel for the petitioner is directed to file a supplementary affidavit bringing on record the order which the petitioner has challenged in this appeal. When do you want?
I'll be filing in next week itself, next Thursday, Friday, if your lordship, whatever.
List this case on in the next week, as requested. Full stop.
List.
Okay, thank you.
Hello, Kotmat Sahib.
Hello. Jan